everyone. Welcome to Special Interests with Bob and Donna, Bob Banfelder and Donna D'Erasmo. For those of you who don't know who we are or your first time tuning into our channel, I am a retired educator with the New York City Board of Education. I retired in 2003. And Robert is the one with all the credentials. He is an award-winning crime thriller novelist and outdoors writer. He is a member of the New York State Outdoor Writers Association, the Outdoor Writers Association of America, and a recent recipient of the Lifetime Achievement Award for his fiction and nonfiction from Who's Who in America. Special Interests with Bob and Donna is an eclectic channel. We cover a lot of topics, and one of the topics that we're going to cover again today, which we did before, is the Karina Vetrano.
Well, we didn't actually cover it. I just
touched on it.
And okay. That's what we're going to be getting into. I'll kind of weave that through.
All right. Well, it's going to be your show today, Robert.
Okay.
So he's going to be discussing the Karina Vetrano murder case and the ancillary information that surrounds it. So I'm going to go behind the camera and I'm going to leave it to you.
Okay. Now, before you do that, you were mentioning credentials. You gave a little, explained a little bit about yourself, but one of your credentials is you were math coordinator for district.
For District 6 in Manhattan. Yes,
okay.
that was
math coordinator. So I may be calling upon you for some equations. Okay.
Oh no, please don't.
No, you'll be able to handle it.
Okay, folks. Well, if you like the show and you find it informative, give us a thumbs up, and please subscribe to our channel for more videos. So I'm going to leave it to Bob, and he will continue.
Okay, thank you, Donna. All right. I am a writer, not necessarily a speaker. I mentioned last time that I would be reading, I would be excerpting from A, B, and C. And what we're going to cover today, I've written, but I'm going to primarily read from what I've written so that, again, I don't miss a beat here. On our last YouTube show was posted March 30th of this year. Don and I addressed the death penalty issue in a segment titled New York State Death Penalty Debacle, Clearing Away the Cobwebs for a Comprehensive Understanding and Instilling Common Sense Solutions. The program dealt with the demise of the death penalty statute in the state of New York, killed in 2004 because it was deemed unconstitutional. Don and I covered the whys and wherefores presented by the appellate court, the highest court in the state of New York. I pointed to flaws in a judge's deadlock instruction rendering a murder trial here in Suffolk County in which Stephen Laval raped and stabbed Cynthia Quinn 73 times in the late 90s. The deadlock instruction meant that if a jury failed to reach a unanimous decision, the presiding judge would then sentence the defendant to life imprisonment, but with a parole eligibility proviso after 20 to 25 years to life. That deadlock instruction should never have been written into law. I said that on the last show. I feel very strongly about that. In retrospect, the appellate court felt. I should emphasize certain words here so that you get the flavor of how the appellate court thought on this matter. In retrospect, the appellate court felt that the jury might impose a death penalty on a defendant whom they believed did not deserve it, but fearing that the defendant might someday be released from prison because of a parole eligibility condition set forth by the judge, if a jury failed to agree unanimously. It seems that a good deal of supposition and second-guessing on the part of the appellate court wrapped around feelings, might-haves, beliefs, fears, and ifs led to that court's decision, led to that court's conclusion. I had pointed to the fact that a trial judge coercing a jury to reach a unanimous decision is counterproductive and can be disastrous, resulting in mistrials and costly retrials. Unfortunately, jurors who fall within the minority are usually pressured, not necessarily persuaded, by the majority of its members to give in, to cave, if you will, so as to end the ordeal, issue forth a unanimous verdict, and return home to their families. Not many jurors want to be sequestered or to keep traveling back and forth between court and their homes. Such was the case for murder victim Karina Vetrano. That's V-E-T-R-A-N-O, Karina, from Howard Beach, Queens. It was a recent trial, actually a retrial here, a high-profile case in Queens, New York. The initial 2018 trial of accused killer Chanel Lewis resulted in a hung jury. The evidence presented appeared irrefutable. However, the jury could not reach a unanimous decision, as 7 were in favor of convicting Lewis, while 5 jurors were not convinced of Lewis's guilt. The jury was hopelessly deadlocked. Hence, the judge declared a mistrial. In the 2019 retrial, Chanel Lewis was found guilty. A unanimous decision had been reached. However, the sentencing phase had been postponed because of alleged jury misconduct. A motion was filed by the defense. One juror stated that he had been pressured into voting for a guilty verdict. Another juror said that the jury foreman had stated before deliberations even began, and I quote, "Well, I have my mind made up, and I hope you do too." In the same affidavit, 2 other jurors were accused of using their own experiences to influence the outcome of the trial. One juror, supposedly as a victim of rape, wow, while the other had been a juror in a prior rape trial and was allegedly evaluating evidence as it pertained to the current trial. After a hearing, the judge denied the defense's motion. Tied to these kinds of allegations, I have in the past presented support for the presence of a professional juror in the jury room to ensure that the evidence is being examined in the proper light. and that time is spent deliberating reasonably, not speculating erroneously or improperly. That would certainly be a prudent consideration. The professional juror would serve solely as a monitor. We'll give him the title professional juror, but he'll serve solely as a monitor, not as a member of the jury, offering no subjective input or casting a vote for guilt or innocence. Had there been, and this is what I've been pushing for and talking about for years, had there been a majority or supermajority rule of law in place referencing the initial 218 Chanel Lewis murder trial, seven jurors in favor of conviction, 5 jurors against. Now, if Donna's math is correct, okay, the upshot, and it is, I'm kidding around before, the upshot would have been factored out to 58.34 and 41.7 against. The majority would have ruled. In this Karina Vetrano trial, you would not have had a hung jury, consequently, a mistrial. You would not have had the antics with this supposed allegations by members of the jury if you had a professional juror in the jury room. The majority would have ruled. To reiterate, coercing jurors to reach a unanimous decision is counterproductive and can prove disastrous, costing the courts considerable time and money, not to mention the prolonged anguish experienced by respective families and friends. And what if a jury is split among 12 jurors? Say 6 jurors deciding that the defendant is guilty, while 6 jurors deciding that the defendant is innocent. The solution is simple. To eliminate any such circumstance, you would change the law and install an 11 or a 13-member panel in lieu of the current 12-member jury. Lawmakers can either put in place a majority or supermajority ruling in lieu of an inane, unanimous jury finding. You have now eliminated a hung jury mistrial. You no longer have this debacle. Well, how did the preponderance of evidence escape those 5 jurors in the initial 2018 trial? Namely, the overwhelming DNA evidence, forensic evidence, and the defendant's confession. That's a question, really. How did the preponderance, how did this happen? Well, obviously, 5 jurors believed that Chanel Lewis's confession had been coerced, and or that the DNA evidence found on or under Karina Vetrano's fingernails, upon her back, and on her cell phone, matching Lewis's DNA, had somehow been flawed or perhaps planted. Which brings me to a point of paramount importance. Alleles. What are alleles? Well, first of all, let me spell it so that you can look it up. Alleles. Alleles. Simply put, alleles are DNA sequencing codes that occupy a given position on a part of a cell nucleus, the chromosome, that contain our genes. DNA analysts, in other words, lab technicians, generally use a standard count of 13 alleles, which establishes a probability ratio numbering in the billions that a collected sample such as blood, hair, saliva, or semen belongs to that particular individual. We're not talking about hundreds of thousands with this standard of 13 alleles. We're talking not in the millions, we're talking in the billions. The science is absolutely great. However, there have been countless cases where incompetent lab technicians have misinterpreted basic samplings, arriving at erroneous determinations. These drawn conclusions have bordered on everything from sheer stupidity to a rush to judgment. Now, listen to that word, sheer, or phrase, sheer stupidity. Now, this is not Bob Banfelder saying they're stupid out there. Let's listen, let's go into an article which I would like for you folks to chip away at. An article that appeared, and I'm only going to excerpt, don't get nervous, let me just see over here, it's like 15 pages. But if you want to learn about DNA, and if you want to learn, or if you don't believe that our criminal system, criminal justice system is not broken, this will be an eye-opener. And I'm just going to quote a didactic statement here regarding the Houston Police Department Crime Laboratory. I should really tell you the name of this article. How about that? The False Promise of DNA Testing, written by Matthew Shear. And that was written in The Atlantic in June of 2016. The Houston Police Department Crime Lab, among the largest public forensic center in Texas. By one estimate, the lab handled DNA evidence from at least 500 cases a year, mostly rapes and murders, but occasionally burglaries and armed robberies. Acting on a tip from a whistleblower, KHOU 11 television station, had obtained dozens of DNA profiles processed by the lab and sent them to independent experts for analysis. Guess what? The results: William Thompson, an attorney and a criminology professor at the University of California at Irvine, told a KHOU 11 reporter. They were terrifying, the results. It appeared that Houston police technicians were routinely misinterpreting even the most basic samples. And I'm still quoting here, if this is incompetence, it's gross incompetence, and repeated gross incompetence, Thompson said. You have to wonder if the techs could really be that stupid, unquote. We left off with my partially quoting that stupidity and the rush to judgment. Rush being the operative word. Police have been under tremendous pressure from superiors to solve a case. DNA labs housed in the same building as police create a questionable environment. Think about that. Putting pressure on technicians to expedite their findings. You ready for this? In some states, a monetary incentive amounting to hundreds of dollars was given to a lab for a discrimination that resulted in a conviction. You determine that this person's guilt. Maybe it wasn't a nefarious tactic, but you're being pushed into this corner, and the lab is getting hundreds of dollars. If we can conclude that this person is the perp. Now, that's really the tip of the iceberg. We're talking about basic forensics here, and these situations occur. It's just a wee bit more complicated. The science gets more complicated and especially difficult to interpret when collected forensic samples contain a mix. Meaning, a mixture when collected evidence contains DNA from two or more people. For an eye-opener referencing the above, again, I'll reiterate, read the article in the June 2016 issue of The Atlantic by Matthew Shayer, S-H-A-E-R, titled The False Promise of DNA Testing. It will wake you up to the reality of forensic techniques and their reliability. The science is only as good as the people behind it. I strongly suggest, and have for years, that initial DNA lab findings and determinations are followed up by an independent lab expert with a sufficient number of years of experience, not a freshman analyst whose conclusion is the final say. Let's go back to Chanel, Mr. Chanel Lewis. In dealing with confessions that were allegedly coerced, as was the pronouncement of Chanel Lewis's defense team, audio videotaping should begin from the moment the suspect enters the interrogation room at police headquarters to the moment the conversations are terminated. Picked up again and continued to their conclusion. A word to the wise. Police tactics such as sleep, drink, and food deprivation as a means of eliciting a confession must be brought to a halt. Threats of bodily harm and physical abuse must cease, halt, and desist. An example, shackling the leg of a scantily clothed or naked suspect to the floor in an 8-by-8-foot interrogation room for hours on end must end. Well, I have secondhand information regarding this. As a matter of fact, I have seen pics of this. As mentioned in the other program, I believe I mentioned that I was on the Robert Schulman serial killer trial every day for 15 months. Saw, heard the good, the bad, and the ugly. And I subsequently wrote a book, wrote a novel called Trace Evidence, wanted it to be nonfiction, but I covered that whole enchilada gave the whys and wherefores. But Poor Dog That Can't Wag Its Own Tail, Trace Evidence by Bob Banfelder will give you an eye-opener. Of course, it's in novel form, but a lot of it is based on fact. If a suspect or the accused, difference, suspect, accused, or defendant, we reached that stage, fails to give a confession, live with it. Oh, easy for me to say. Rely on a new system of laws as proposed in order to repair a broken criminal justice system. Put the preponderance of evidence in the hands of players who take up sides in a courtroom, the prosecution and defense. Then let a jury decide a defendant's fate. Not a unanimous decision, but a majority or supermajority decision. Woe to those officers of the court who suborn perjury, meaning to induce someone to lie under oath. Oh, Donna and I know about situations like this. Regarding a case that I was on, I came into it later, regarding Richard Chilingarian, accused of the attempted rape of a high-ranking police officer's daughter. The detective went next door and learned certain information that exculpated, and I'll talk about that in a second, exculpated Richard Chilingarian. It was never mentioned in court. It was not brought to the ears of jury members. Woe to those who withhold exculpatory evidence, meaning evidence favorable to a defendant in a criminal trial that exonerates or tends to exonerate the defendant of guilt. That should be your only grounds for a mistrial if something like this happens. And the culprits, the officers of the court, should be dealt with severely. Not immune from prosecution, as is the case in certain situations. The evidence that weighed heavily in my mind in People versus Chanel Lewis murder trial was not necessarily DNA oriented, but rather the fact that Chanel Lewis had gone to the hospital on the evening of Karina Vetrano's murder. The attending doctor had said that Lewis's hand injury was consistent with that of a person punching someone hard in the face. Karina had been brutally beaten, and 2 of her teeth were broken in the attack. Back to having DNA findings, say by a freshman lab technician, analyst, moved on to someone with great experience. I'm going to mention a name here. As I was giving a talk on the Robert Shulman serial killer trial, after 20 years, a forensic scientist came out of the woodwork. He was the 3rd one to testify in the Robert Shulman serial killer trial here in Suffolk County. And this fellow went on, he tracked me, found me, and said, oh, do you remember me? Of course I remembered him from the trial. we're talking about a lot of years of experience. He was with Cellmark Diagnostic Center then in Delaware. And today, he has over 30 years of experience. No, I stand correct. He has 23 years of experience. That's where, when a conclusion is drawn of a person's guilt, I would like this to go off to an independent lab comprised of people, scientists like Glenn Hall, lab director of Michigan State Police, Northville Forensic Lab. Then you have credibility built into this. You don't have police in the same building as the lab technicians. It would carry more weight. And when you get into these complicated DNA analysis that I mentioned, talking about mixes coming from, the blood, saliva here, they're coming from more than one person, it becomes more credible, more credible if you have someone like a Glenn Hall with years of experience. Let's say not everyone's going to have 23, 30 years of experience. Let's say they'll throw out a number, 9, 10 years of experience. Not a lab technician, a cub, a freshman, if you will, who's making a conclusion, holding in a balance someone's life with a year or two of experience. As a matter of fact, people have been fired. I won't mention the name. She's been beaten up enough, and she had a lawyer that had her reinstated after being fired because of poor supervision. So, poor supervision. See, we shouldn't have that issue. Had we a majority or supermajority rule in the first place, in lieu of a court foolishly striving for a unanimous verdict by compelling 12 members of a jury to be of a single mind, is simply mindless. The unnecessary ordeal of a second trial followed by a hearing on jury misconduct before sentencing would not have happened had we had sensible laws in place. Here's what broke my heart. The frustration and unnecessary additional stress put upon the Vetrano family had been extraordinary, documented by their powerful, heartbreaking victim impact statements, not to exclude the suffering of the Lewis family. Majority rules should be the law of the land. And I think we'll kind of conclude here, and maybe for another show, we'll get into DNA a little further. I have some very good analogies that will really make this pretty clear. The failures that results, well, like I said, we'll just leave it here for now, and maybe we'll move in that direction for another show. That's about it, folks. See you next time.